hear me or not hear me, whatever the case may be. Thanks, Rukhsar. Now let's start with federalism today. And if I remember correctly, we had left by merely introducing the idea of federalism, but we had not discussed the concept of federalism and specifically how federalism evolved in Indian context, specifically how it evolved in Indian context. Now, before I proceed, and before I forget towards the end of the lecture, in your classroom, you might have received a notice and you might have seen that I have uploaded few materials in a folder called federalism. Okay. Now there are two materials. Now one is obviously a list of writings from the Oxford Handbook of the Indian Constitutional Law. So you will find several articles by at least 4-5 articles there, which concentrate on different aspects of federalism. So, for example, you have MP Singh's article, which is talking about how the entire constitution has a federal scheme. Then, how federalism and the distribution of legislative power between state and the union, interstate trade and commerce as a part of federalism, interstate water dispute as a part of federalism, fiscal federalism as a part of federalism, local government and asymmetric federalism. So there are these 6-7 chapters which are listed there. So you can have a look at them. Okay. For those who are interested in understanding various aspects of federalism, obviously we will not be able to discuss all these writings in detail in the classroom, but obviously just go through them and we can, if you have any questions regarding it, we can use it to further enrich our classroom discussion. And the second is a very interesting article called "Is Federalism a Viable Alternative to Secession?" Now, this is a chapter from, and this is an extracted chapter from a book called "Theories of Secession." Okay. Now, when we discuss Article 2 to 4, obviously secession would also we will try and devote some time to this idea of secession as well. Now, what is argued in this article, the second article that has been uploaded in your Google Classroom is can secessionist tendencies be sort of restricted and then limited by promoting federalism? And this makes for a very interesting read for those who want to understand what are the different virtues or disadvantages or advantages attached to federalism. So these are the two files that I have uploaded. You all can go through it whenever you have time. Obviously, sometimes question is asked that is it important from examination point of view? But some of you have been asking that question in some of the sections. So maybe not per se, in the sense that obviously you can your passing an examination in Indian universities is obviously not very difficult. It's a very easy task. But yes, it is definitely, all these articles and all these readings are definitely important if you want to develop an understanding and if you want to learn. So I'll just try and go through these articles. Now coming back to our discussion on federalism, okay, and how federalism evolved in Indian context. Now, as we had discussed that federalism has the concept of federalism basically talks about, at the core of concept of federalism lies the idea of decentralization. Okay, that power must not be centralized. Now, this decentralization operates in two manners. One form of decentralization is horizontal decentralization. Now, when I say horizontal decentralization, it means that there is a decentralization of power between three wings of the government, that is the judiciary, the executive, and the legislature. Okay, and this form of decentralization is known by the name of separation of power. Okay, that is horizontal decentralization. Now, the other form of decentralization that we can talk about is vertical decentralization, wherein power is decentralized between different units of a polity. So, for example, power is decentralized between the federal and the constituent units. That is vertical decentralization. And if you take Indian vocabulary, then there's a power is decentralized between union and the states. So, federalism, at the core of federalism lies the idea of decentralization. However, that does not mean that all forms of decentralization are essentially federalism. Federalism is just one form of decentralization of power and not all forms of decentralization of power. Okay, that you need to be very clear about that. Now, having said that, at the core of federalism lies this concept of decentralization. Then, what is the characteristic feature of this federalism form of decentralization, or the form of decentralization that we know as federalism? Now, the characteristic feature of this form of decentralization is one, the concept of demarcated jurisdiction. So, like we discussed in the previous class, that jurisdiction is demarcated between the federal and the constituent units. So there will be some kind of demarcation of jurisdiction. Now, what are those various facets of demarcation, for example, that we find in Indian Constitution at least, is there will be a demarcation in the legislative power or the legislative jurisdictions of or the competence of the union and the state government. Where is this found? It is found in Schedule 7, the 3 list. Union list, state lists, and concurrent lists. So what we are doing is we are demarcating the jurisdiction of both the union and the state with respect to what are those spheres on which the union can make law and what are those spheres on which the state can make law. So this is one example of demarcated jurisdiction. Obviously, there is a demarcation of jurisdiction also when it comes to executive power, but this is one example in order to make you understand what is demarcated jurisdiction. So we started with the idea that federalism is about decentralization. It is one form of decentralization of power. And what are the characteristic features of this form of decentralization of power that we know as federalism? The first is that obviously there is demarcation of jurisdiction. And the second is that the different constituent units in federal structure are to an extent autonomous of each other. They function in an autonomous manner. Okay? From each other. That does not obviously mean that there will not be any kind of reliance between these units. There is a reliance, and this is something that we will subsequently, not maybe right now, but subsequently we will understand. We will analyze the autonomous nature of these constituent units in federalism by looking at two concepts of federalism that have gained currency today, that is competitive federalism and cooperative federalism. But for the time being, because we have just entered into a discussion on federalism, let us just understand that federalism is a form of decentralization of power, and the characteristic features of this form of decentralization of power is demarcated jurisdiction and some form of autonomy of the federal and the constituent unit, or central or union and the state or provinces. So that is one aspect of federalism that you need to keep in mind. Now, today a major portion of our discussion would be dedicated to understanding how federalism evolved in India, because Indian federalism is an experiment of sorts. And we have several criticisms which are made against Indian form of federalism, wherein it is often argued that Indian federalism is not actually a federal model. India is not a federal model. And there are some people who said that India is a sui generis federal model. What I mean by sui generis, that it's an indigenous form of federal model, unique in itself. But that does not imply that it is not a federal. Now, generally such kind of claims are made against Indian federalism, both in favor of Indian federalism or against Indian federalism, is because when we understand federalism, we understand it from the perspective of classical federal model. Now, what is a classical federal model? The US is an example of classical federal model, wherein different constituent units come together by giving some of their powers to formulate a federal government. Okay, so different units, for example, in United States, different states or provinces or independent states or independent provinces came together to form a union of those provinces or states that is known as United States of America. And in doing so, they gave some of their power to the union or the federal government. Okay. Now, that is a classical federal model where different constituent units agree between themselves to constitute a federal structure. That is a classical federal model. Now, Indian federal model or Indian federalism was not born in that manner. Rather, Indian federalism was born in a manner that the union was envisaged first, or the federal was envisaged first, and thereafter constituent units were formulated. Okay. And the reason why these constituent units were formulated, and this is something that we will discuss, is basically to accommodate the plural expectations and aspiration and cultural requirements of the different constituent units. So what we need to understand is that Indian federal experience, or the manner in which Indian federalism evolved, is not the classical federal model. Now, just because it does not fall in that classical federal model, the question that you can ask yourself is, does it imply that Indian federal structure is not a federal structure at all? That is the question that you have to ask yourself. That is India even a federalism if it does not conform to this idea of classical federal model? And this is what we will try and understand by discussing how is it that the idea of federalism came in India. Okay, how is it? Now, if you look at how federalism evolved in India, it was actually introduced in India by the colonial government or in the colonial rule. Now, as I told you, federalism is a vertical decentralization of power. So the power is decentralized vertically. Now, in India, the primary decentralization of power occurs between union and the state. But there is also a scope of further decentralization of power, which is obviously contemplated in India and is provided for in India, but is not as concretized as this distribution of power or decentralization of power between the union and the states, and that is in the form of local governments. Okay. So what you will find is that in this vertical decentralization of power, what is the possible manner in which the hierarchical form of decentralization, the possible hierarchical form of decentralization is not just union and the state, but it can go further and be union, states, and local governments. Now, obviously, our local governments are developed to an extent, but they are not as concrete and do not hold as much power, obviously, as the union and the state government. Now, it is in this regard that you have to understand that how federalism was introduced in India. So, you must have, if you have read history in your schools, you must have heard of Lord Ripon, who was Viceroy of India in the 1800s, right? So it was the first time that, and if you remember, that he was generally called Good Old Ripon as opposed to other viceroys at that specific time, because he did try to bring in some kind of lenient laws in India. So what happened in 1882 was that the idea of local government was introduced in 1882. Now, how through Ripon resolution. Now, what you need to, however, understand that this introduction of local government was not a benevolent gesture on the part of colonial rulers. No, it was not. It was rather to further strengthen the hold of colonial rule in India, because what was felt because it was just after 1857, and what was being felt was that Britain needs to find different new ways of ensuring that no further mass revolts happen against the colonial rule. So the reason why local government was introduced in India was merely to strengthen their hold over India, so that they could co-opt co-opt indigenous people and use their help and assistance to administer India. So that is the reason why local governments was introduced. But the emergence of local government definitely led to the emergence of this vertical decentralization of power. So what you will realize is that though we understand federalism presently as decentralization of power primarily between the union of the state, federalism, the idea of federalism, that is the vertical decentralization of power, was introduced in India by introducing local government, something that is not as important a part of Indian form of federalism today. Now, having said so, what we find is that introduction of local government way back in 1882 was something that laid the seeds of federalism in India. Now, subsequently, obviously, you will find the main form or the present federal structure is borrowed from Government of India Act 1935. And I'm sure all of you must be aware of the fact that a large portion of the Constitution of India is actually borrowed from Government of India Act 1935. So that's why sometimes a claim is also made against the Indian Constitution that Indian Constitution is also a form of a colonial legacy, because what we have done is we have borrowed that a major portion of Indian Constitution borrows from a colonial piece of legislation. But obviously there is a counter claim to that assertion, having said so that even though it is borrowed from different, not only from colonial piece of legislation, but also from different jurisdiction, the manner in which constitutional law, the Indian Constitution has operated has unfolded itself is that it has been Indianized to a very large extent. So those are some claims which are made against Indian Constitution in itself. Now, what we will find is that a large chunk of Indian federal model has been borrowed from Government of India 1935, because that was the first time perhaps where the present federal model was introduced in India. Now, if you look at Government of India 1935, you will find three types of units which are federal units which are provided, or at least three types of units which are provided in that act. One is something which is called the provinces. The second is the princely states, and the third is the chief commissioners' provinces. Now, chief commissioners' provinces is something that we today known as union territory in India. Now, when 1935 Act was formulated, what happened at that specific time was that while it was obligatory for British India to be a part of that provinces of British India to be a part of that federal structure, princely states had the option to either join or not join the federal structure contemplated in 1935 Act. So there was this option which was given to the princely state to either join or not join the federal structure. Now, while 1935 Act did introduce some form of decentralization of power, what you need to understand was that still a lot of power still remained with the federal unit, or that is the center. The reason being that, for example, and this is something that we have again borrowed in the present constitution, the Governor General had the power to issue ordinance. That means the Governor General had the power to override the legislative aspirations and issue ordinance as an executive made law. There was also this provision of emergency provision, which allowed the Governor General to take up the entire governance of provincial province. Resonates very much with Article 123 and 213 of the Constitution, as well as Article 356 of the Constitution, right? Wherein we have also today also we have something called ordinance, and we have something called the imposition of precedents rule, wherein, and even in national emergency, but otherwise also it is felt that that a specific state is not able to apply constitution in a proper manner, the union may take over the administration of the state. So what you will find is that right from the very beginning, it is 1935, there was, even though federalism was invoked, a lot of power resided with the center or with the Governor General in 1935. But the question that may come to your mind is that it makes sense to give more power, or you can still understand the logic of giving more power to the federal unit or to the Governor General in 1935 Act, because obviously we were living under a colonial rule, and the colonial rulers were obviously not comfortable with giving power or decentralizing power, because then that would have led to the opposition against the colonial rule becoming stronger and stronger. So it made sense to have to sort of decentralize power, but at the same time also hold reins to the power. But why is it that the question that you may ask is, and why do we find such centralizing tendency? And when I mean centralizing tendency, that the balance of power is in the favor of the center rather than the states. So this made sense in the British rule, in the colonial rule. But why do we find a centralizing tendency even in Indian constitution today, that is post-independence constitution? Why is it that we have still retained, let's say, provisions like ordinances, provisions like Article 356 of the Constitution, wherein the Union has the power to impose precedents rule, or provisions like Article 1 to 4 of the Constitution, where the state does not have the power to alter the boundary, but the Union has the power to alter the boundaries of the state. And the only thing that the state can do when the boundaries of the state are being altered is perhaps agree or disagree, or give a recommendation. But that recommendation is not per se binding on the Union. Now, this is something that we will discuss subsequently when we are discussing Unit 2. But what you will find is that you do find a sort of centralizing tendencies in Indian constitution, even in the post-independence era. So that might force you to ask yourself, why is it that we have such centralizing tendency? Okay, what led us to have the centralizing tendency? Now, if you look at the Constituent Assembly debate, it was not always presumed, or it was not always given that center is going to have more power, or the union is going to have more power than the state. It was not always a given thing. But there were certain political considerations and political experiences that led the Constituent Assembly members to rule in favor of having a federation with a centralizing bias. Okay, now that is, and one of those reasons being partition. Now, what had happened was that, because if you remember, we gave ourselves the Constitution on 26 November 1949. Some portions of the Constitution came into force on 26 November 1949, and the rest on 26 January 1950. So, what you will find is that so when partition happened, we were still deliberating on our Constitution. The Constitution was not finalized at the time of partition. Rather, we were just about 1 year into a deliberation into Constitution when partition happened. Now, post-partition and even the period prior to the partition is marked by communalism in India and also in the present-day Pakistan. So we find communalism becoming a very perceptible threat to national integrity. Now, you can understand, just try to put yourself in the shoes of the Constituent Assembly members and try to look at it from their point of view, that what would a newly independent nation and the leaders of a newly independent nation consider more important? It would obviously be to maintain the integrity of this newly independent nation. First, so that the idea of India does not fail as soon as it is born. So there needed to be, so maintaining the unity and integrity of India must have been a priority in their head, and not allowing communal forces to in any manner disrupt unity and integrity of India, because understanding from their point of view, a disintegrated India would have all obviously been in favor of the colonial rulers. Even if you look at history, and there is a very interesting book on Kashmir by Aman Hingorani called Unraveling the Kashmir Knot, where he gives historical evidence as with regard to how partition of India was finalized much before 1947. This was a part of the policy. And one of the reasons, it was a part of a calculated international geopolitical move, that as to why India was partitioned on religious line. So so having a disintegrated India would very well have satisfied the political motives of the colonial rulers. So just put yourself in the shoes of Constituent Assembly members, go back to 1946 and try to put yourself there. Just post-independence, we are suffering from communalism, and should we give more power to the federal units? Because by giving more power to the federal units, the power of the center to ensure that these threats can be controlled would somehow be diluted. And that is one reason that after partition, it was a consensual decision, uniform consensus that we need to give more power to the center over the states. So center needs to have more power. The union needs to have more power than the state, because otherwise, after the partition, all the communalism and the manner in which there was a need to also integrate the refugees in our country, etc., would resettle the refugees, ensure that there are no further communal flare-ups in India per se, could only be attained if we gave more power to the center or the union. Okay, so that is one of the main reasons why you find a centralizing bias in the Constitution of India. Don't look. So you need to understand the context in which Indian federalism, at least federalism as we see in Indian Constitution, was born. Now, the second important aspect being that, and this is something that you must have heard several times, that not all princely states wanted to be a part of India initially. There were several princely states who had sort of reluctantly joined India. And the reluctance was more pronounced in respect of at least three princely states that we know of, that is Hyderabad, Junagadh, and Kashmir. And we see how different methodologies were used to include those princely states in India. So while we had a full-fledged military battle in Hyderabad, we had a referendum in Junagadh, we accorded special status and a special treaty with Kashmir. So how these three states were made a part of India. Now, apart from these three states also, several states were not very happy to join to something called an integrated union of India. There was a form of reluctance. Now, in the backdrop of this reluctance of princely state, obviously, you can understand that the constitution framers thought that if we give more power to the provinces or to the states, there is a possibility that these states would not completely integrate with India. And that is the reason why again, another reason why you will find a centralizing bias in Indian Constitution. One, to overcome the communal flare-up or the communalism in India, and the second, obviously, to ensure that these princely states do not subsequently withdraw from their acceptance of this of Union of India or Republic of India, and that is why more power was given to the center or the Union instead of the princely state. And the third also important factor was obviously something financial reason, because what we what was realized that because India as a country has inequitable distribution of resources between different countries, different states. So some states are extremely rich in natural resources, and some states are poor in natural resources. So what you will find, so what was felt was, if we want to, because finances were an important consideration, the British had completely drained the Indian population. So what was required was that there needed to be a very streamlined plan in order to ensure economic growth of India, and that could only be done if internal conflicts can be avoided, and internal conflicts can be best avoided by giving more power to the unions rather than to the provinces. Otherwise, if provinces are given more power and they start asserting themselves, and are reluctant to share their resources with other provinces, a weak union will not be able to resolve those conflicts. It is only when we have a strong union that those conflicts will be resolved. So that is one important, another aspect why you find a centralizing tendencies in the Indian constitution. Now, so having understood the reason behind the centralizing tendency, let's just come to different examples wherein we will find those centralizing tendencies. Now, what we will do today is that we will just briefly look at those examples because and the text of the Constitution. So examples are picked up from the text of the Constitution, and the reason why we will briefly look into those examples is because obviously we are going to deal with them in much more detail in our course. Because as I told you, this course, Constitutional Law 1, mainly deals with two aspects. It mainly deals with decentralization of power, both vertical and horizontal. So we will be discussing about different examples of federalism, and we will also be discussing about different examples of separation of power. So we will be discussing decentralization in Constitutional Law 1 syllabus. Now, so let us just try and understand what are those provisions in the Constitution wherein we find this examples of decentralization. Right now, one example that you can find is Article 2 to Article 1 to Article 4. Now, and I hope you are carrying a bare act of the Constitution with you. As I said, it's very important to have a bare act and a hard copy, not just a soft copy. Now, if you look at Article 1 to 4, Article 1 to 4 are a part of this chapter called, are a part of this segment of Constitution called the Union and its Territory. Now, what does Article 1 to 4 talk about? Article 1 to 4 talks about what is the territory of India and what are the powers of the Union of India to form new states or alter the boundaries of the state. Now, if you look at Article 2 to 4 of the Union of India, what you will find is that while the states do not have a power to alter their boundaries, okay? So that's why we call Union of India as indestructible union of destructible states. Why do we say Indian Union is an indestructible union or destructible state? We say so because the reason being that while states do not have a power to secede from India, okay? Because if the state secedes from India, then the Union of India would become destructible. Okay, so the states do not have a power to secede from India, but the Union has the power to alter the boundaries of the state. So the boundaries of Union of India as a whole cannot be altered. But within that boundary of Union of India, the boundaries of different provinces can be altered. That's why India is an indestructible union of destructible states. And who has the power to alter the boundaries of the state? The power has been given to the Union, not to the state. So when we discuss Article 3, Article 4, you will find the Parliament which has the power. That is the Union which has the power, the Parliament which has the power to alter the boundaries of the state, but the state cannot tomorrow say that we no longer want to be a part of India. Okay? That cannot be done. So what you find is the federal government or the union government reserves the power to both alter the boundaries of the state as well as create new state, and the states themselves do not have much of a say in this. And even if they disagree with this alteration of boundaries, the parliament per se is not bound by such disagreements. So that is one aspect of Indian constitution where you will find centralizing tendencies. Now, the formation of states in India is a very interesting read in itself. So, but we will not be discussing it obviously in detail because we don't have that much time. But just to introduce it briefly, that the formation of state in India itself has a very interesting history. Now, initially, India there were demands for organizing the states in India on linguistic lines. But if you look at the initial government documents, what you will find is that there was an apprehension that if we divide India on linguistic lines, then it would lead to disintegration of India in one manner or the other. And this was an apprehension which was there, at least in the mind of our early leaders, especially Nehru, because that there is a possibility that India gets disintegrated into different units if we allow for linguistic reorganization. But subsequently, what we find is that linguistic assertions became very strong in India, and linguistic movement gained a lot of currency. And subsequently, there were divisions of provinces of states on the basis of language. But however, subsequently, it was felt that linguistic division or reorganization of India on the basis of language was not perhaps a very bad decision, and that's why the initial apprehension of the initial leaders has somewhat been mitigated today. Now. Anyway, so we will discuss all of this in detail when we are discussing Article 2, Clause 4. But right now, what we are doing is we are just trying to pick up those aspects of Indian Constitution so that we have a fair idea what all is federalism about by looking at different provisions of the Constitution. Now, the second most important, perhaps the most important aspect of federalism in the Indian Constitution is about distribution of legislative and executive power between the state and the union. Okay? That is the most important aspect. Now, let's first come to the legislative part. So, legislative part, Article 245 onwards, you will find the chapter itself is about distribution of legislative power between the union and the state. Now, where is it that you, in a sense, find distribution of legislative power? That is Schedule 7. So, maybe you can open your Schedule 7 in your Bare Act and see that in Schedule 7 of the Constitution, there are 3 lists. Those 3 lists being union list, state list, and concurrent list. And all these 3 lists have different subject matters. Now, on union list, it's only the union government or the parliament which has the power to make law. Similarly, state list, it's only the state which has the power to make law. And subsequently, in concurrent list, both union and that is the parliament and the state legislature has the power to make law. So there is a distribution of power between union and the center. Union and the states. But what about those subject matters which are not found either in list 1, list 2 or list 3? That is the residuary subject matters. Okay. Now, the power to frame laws on residuary subject matters rests with the parliament and not with the state. Now, this was again a deliberate decision. So, what you will find is that we have borrowed our federal model from Canada. If you look at even 1935 Act, the manner in which Indian federalism was structured was on the basis of Canadian and Australian federal scheme. So, in India, what you will find is that the power to frame laws on subject matters which are not mentioned either in List 1, List 2 or List 3, which is known as res judicata power, is vested with the Union. Again, a centralizing feature, right? It's not that you are vesting it with the state. Rather, whatever is not mentioned in subject matters which are not mentioned in either of the lists, the power to frame laws on those subject matters vests with the Union. So again, another feature of centralizing tendency in the Constitution. Now, what about executive power? Generally, the executive power is coextensive with the legislative power. So, whatever are the subject matters on which the parliament can make law, the executive power of the union government would extend to those subject matters. And similarly, the subject matters on which state legislature can make law, the executive power of the state executive extends to those subject matters. So, that is how executive powers of the union and the state function. But what you will find is that there seems to be again a centralizing bias in favor of the union government, especially when we look at emergency provisions. Now, and specifically Article 356 of the Constitution. So we have an entire unit which is devoted to emergency, and where a major chunk of our discussion would revolve around Article 356 of the Constitution. Now, if you open Article 356 of the Constitution, what you will find, and we'll just briefly summarize what 356 says, is that in case there is a failure of constitutional machinery, the union government may take over the administration of the states. So that means that the state legislature no longer has the power to frame laws. Legislative power of the state vests in the union. Executive power of the state also vests in the union. And the union can usurp the executive and legislative power of the state. Very similar to what was there in 1935 Act, wherein the Governor General could exercise emergency powers and take over the administration of the provinces completely. Now, so this is actually similar to Article 356 is similar to Section 93 of the Government of India Act 1935, wherein the union government had the power to take over the administration of the states. Now, there was a lot of debate on whether to insert Article 356 or not. Many people did not want insertion of Article 356 because what was felt was because they had already experienced the manner in which such a provision was abused by the colonial rulers, and they did not want the history to repeat itself. However, Article 356 was inserted, but with extreme caution. And what was expected that Article 356 would only be invoked in extreme scenarios. Okay. Only when there was actually a failure of constitutional machinery. And it should be, and if you look at Ambedkar's speech on Article 356, what he argued was that it must be an action of last resort. It should not just be invoked whenever required, but must be an action of last resort. So when we study Article 356, but post-independence, in our experience, what we experienced was there was an excessive invocation of Article 356, and thereafter several frameworks or regulations or law had to be clarified by the judiciary in order to basically lay down the ground rules on the basis of which Article 356 could be invoked. So it was not that the Constituent Assembly members was not wary of the problems associated with a provision like Article 356. They nevertheless introduced it in the Constitution with the expectation that the government of the day, or the government at the union government of the day, would have the would have the sensibilities to invoke it as a measure of last resort, and would not use it to destroy opposition. So that is another aspect of centralizing tendency in the Constitution. And obviously, apart from that, there are other emergency provisions also. For example, national emergency under Article 352, or financial emergency under Article 360, wherein the administration of the entire country becomes unitary in nature and the federal structure is temporarily suspended. So in emergency under Article 3052, federal structure of the Indian Constitution is temporarily suspended, and the Indian polity assumes a unitary characteristic feature. The next aspect of Indian federalism is obviously the fiscal federalism, wherein there is distribution of revenues between the state and the union. Obviously, after the introduction of goods and services tax, a lot of the erstwhile fiscal distribution of power has been modified, but there is still a form of fiscal federalism in India. A brief history and contextualizing how federalism has evolved in India per se. Okay. Now, because we only have 10 minutes left, I will just introduce an idea to you, and we will discuss this concept in detail tomorrow. And for that, maybe you can read in the readings that I have uploaded on your classroom. Maybe you can read Louis Dillon's article on asymmetrical federalism. So, and because the next concept that we will be discussing is asymmetrical federalism. And what is it that is meant by asymmetrical federalism? Now, anyone who has an idea of what is asymmetrical federalism? Asymmetric federalism? Anyone who can explain what is asymmetric federalism? Okay, no one. Fine. Now, what we mean by asymmetrical federalism is that there is asymmetry, as the term suggests, or different forms of rights are given to different federal units. So there is a form of asymmetry in the manner power is decentralized. Okay, special provisions for, yes, Yogesh, that's a good example actually of an example of asymmetric federalism. That what you will find is that in several portions, because we are ethnically diverse, we are culturally diverse, we are even in the manner of allocation of resources, we are diverse. What you will find is that different rights are conferred. So there is more or less a homogeneity in the manner in which rights are given to provinces or the states, but then some differential rights are also given to certain provinces and the states. Okay, that is asymmetrical federalism. For example, not now, but we had given special status to Kashmir. Okay, that is an example. We have Schedule 5 and Schedule 6 states. An example of asymmetric federalism. Some of the so that's what you will find in Northeast is that certain areas are given comparatively more autonomy as compared to other states. So. Similarly, you have union territories. There is also a division between union territories and the state. So, while union territories is a complete unit in itself, as compared to state, it has less autonomy as compared to state. So, what you will find is that there is a differential difference in the manner in which power is decentralized. And as Yogesh rightly pointed out, one of the examples of asymmetrical federalism is special provisions for constituent unity. Now, so what we will be doing tomorrow is that we will be discussing different provisions which are given in the Constitution, which are an example of this asymmetric federalism in India. For example, Article 370. Now, obviously, we understand that Article 370 has been abrogated, but still, we will use the erstwhile provision of Article 370 to understand why and how asymmetric federalism was brought into picture. Then we have something called 5th and 6th schedules, which is very important. Then we have, if you look at Article 371, through 371J, you will find that there are certain special provisions which are given to some states. So, different articles giving special provisions to different states like Nagaland, Assam, Manipur, Andhra, Sikkim, Goa, Karnataka, etc., etc. And the reason why special provisions, special status is given to different state. So at least these three aspects is something that we will be discussing tomorrow, vis-a-vis asymmetric federalism. If you want to read, you can read asymmetric federalism in the reading on Oxford Handbook of Indian Constitution, wherein there is an article by Louis Dillon, which is on page 540, something that you can go through to better understand the discussion that we will be having tomorrow. Okay. So yes, that is the end of the discussion for today, at least. Please let me know if you have any questions. Okay. If there are no further questions, then let's conclude for today, and then we meet tomorrow. Okay, before concluding, I was just wondering, there was a question that I wanted to. Hello, yes.
Ma'am, can you provide readings for the exam point of view?
You need, from exam point of view, you can just confine yourself to your case material. Okay, so that would suffice, and you can.
We just need to read our case materials.
Yes, that is enough. But I hope that you don't confine your readings to just examination. Obviously, all these readings that are being circulated in the class would obviously help you in better understanding and answering the questions that come in the exam. Okay, so there is one proposal that I had with
ma'am.
Yes, Pooja.
Good morning, ma'am. The material that you are uploading